Hello, everybody. Excited utterance here. Hello. And a bit of a different topic today. We have Chad Daybell, the Doomsday Dad. Yes. I don't think anyone likes Chad Daybell very much. That's Lori Vallow Daybell's fifth husband or something like that. I can't even keep count. She's in the slammer. She's actually in the slammer in Arizona right now. She's awaiting another trial for her deeds in Arizona. But last year, famously, she had her trial in Idaho for the unaliving of Tylee, JJ, and Tammy. Tylee and JJ being her daughter and her adopted son, I believe, and her, well, not her relative, but actually the wife of Chad. So very sadly, Tammy Daybell was unalived, and that was only a little tiny little bit before she and Chad ended up on a beach in Hawaii, and the very famous pictures with the ukulele, etc., of Chad and her having a lovely, lovely time in Hawaii on the beach getting married. Yes. So Chad, he has his trial coming up in just 2 months, and the DP is on the table. Yes, the DP, and not the kind that you get after you've been on Tinder. No, not that kind, darling. Yeah, he's talking from down there. Hello, Dali.
Hi.
Oh, hi. Hello. Oh, hey, we got Tilly in the house. Hello, Tilly. Tilly saying hi to Excammer. Hey, Tilly, I met you over in Sean's chat. Hey, good to see you. Good to see you. Nice to have you over in this chat. Excellent to see you. And yeah, look, it tain't true. Tilly calls me the taint lady.
That's charming. Hello, Brandon.
Oh, Brandon's here too. Look, we'll get to Brandon. We have to say hello to everyone else. Hey, Brandon. Since you say that. Hey, Brandon. How's it going, Brandon? Okay, let's go through everybody else here. We have Nikki. Nikki. Now, Nikki has been off creating some amazing videos, and we should have a look at Nikki's videos. She made me laugh this morning. And it's morning for me, by the way. It's 7:30 a.m. And Nikki sent me off to have a look at one of her videos. Did you yawn?
No, I pretended to be shocked.
All right. Nikki's Bible videos are hilarious, by the way. You should all go and check out Nikki's videos. I will put a link in chat shortly once I stop talking. Yeah, that made me laugh. And who else we got? Stray's here. Hey, Stray. Good to see you. More people from Utah. Who's from Utah?
Mormons.
Oh, Mormons. Yeah, it was Idaho. Yeah, it was Idaho. You just confused me, Excoma. Oh, you put your photo back. You're going to make me cry. I loved your other photo.
Oh,
Bring back the cell photo. Bring it back. It's not fair. Oh, hello, Emu Warrior. Solemn Saturday morning from Melbourne. Oh, is it rainy there? Look, it's going to be rainy around here as well a lot because there is a cyclone coming. And apparently it's a cyclone of the magnitude of 2011, which is very bad, which means that we're all going to flood. But that's what the media like to say every time the cyclone is coming, that it's going to be as bad as 2011 and we're all going to flood. Because the media likes to say stuff like that to scare everybody. So look at me. I don't look so scared, do I? But, you know, next week I could be swimming. There could be water up to here.
It could be.
There could be. All righty. What else we got going on? Yes, Brendan. We said hello to Brendan. Hey, Brendan. Sue's here. Hello, Sue. Hello, Sue. How are you? And Tragic's here. Tragic in the house. You'll be lurking as usual. Who the ho? Idaho. I love it. Who the ho? Idaho. Okay. So, and Half Irish is here also. Oh, what is this? Oh. You are the best troll ever. I love Excomer's trolling. He's the best. You are classic Excomer. I just love you. Oh, that is too good. How good is that?
God damn it.
Oh my God. That's even better than the day you went into the LNC and sent us and went, hey, Sal. That is just too good. Oh my God. That's my new favorite photo too. All right, let's get into this. Oh, Excom is great. Hey, Christine. Oh, wow. Oh, I can hardly speak now. That is just too good. Wow. All right. We have, oh, look at him. Frog mouth. Okay.
It's a handsome man.
Yeah, I was watching, I watched a little bit of Danny Undereck's coverage of this, and she calls him tater frog or something like that, because he looks partly like a tater tot, which we don't have here, but
Mr.
also
Potato
like
Head?
Yeah, Mr. Potato Head or something like that. And yeah, she's, as far as she's concerned, he hasn't been in trial, but he's guilty. And he needs to be locked up. Okay, so just a little bit of background. His defense counsel is John Pryor. Now, he's a private defense attorney, and Mr. Daybell has pretty much spent all of his savings, everything that he has on this defense counsel. He's a good attorney, John Pryor. He's excellent. The whole idea of having this attorney was that he was going to be able to get the DP off the table.
Ooh.
All right. So that was the whole point, that there will be no DP. Right. And he has fought very hard to try and get the DP off the table. But unfortunately, we are 2 months away from trial and no DP off the table. All right. So it's still there. Now, Lori Vallow was able to get the DP off the table, but Chad Daybell.
But she had to do DP for it.
Yeah, exactly.
With the DA.
Yeah. Well, I don't know what she had to do, but she got it. She managed to get rid of the DP, whereas Mr. Daybell, no. Right. So he is heading to trial with the DP on the table, and the problem is that Mr. Pryor is not DP certified. Right. So he is not. Yeah, he is not certified to represent him at trial with the DP on the table, and yeah, DP is obviously deletion.
Your lawyers have to be qualified to do them, and you need special counsel for it.
They should be. They should be. What's this? Hello. Jess, you won't party with the king, you coward. Cheap Aussie wine fuzz. Oh, do you wonder who that is?
I wonder.
Hello. Thank you for the super chat, Jess. You won't party with the king, you coward. I really appreciate
line
that.
read. That's interesting.
Okay, what's this? Stop it. Stop touching things. Oh, God. We both tried to touch it at the same time. Right.
That's what I said.
The DP because the prosecution failed to turn over evidence. Judge Boyce punished them by removing the DP. Aye, interesting. Okay, so I didn't know that little factoid. Very good. Yes, okay. So it wasn't anything amazing that that Lori's defense did. It was something that the state did wrong that got her DP taken off the table. And I'm sure that her defense argued that as well, like that it wouldn't have just been the judge just going, oh, you didn't turn that over, so therefore I'm going to take that off the table. Her defense would have argued it.
Well, they would have asked for sanctions. I don't know if they would have asked for that specifically, but
I would think they would have tried. But that's interesting. Online, thank you for that. Stop touching each other. But here's the deal, right? So John Pryor supposedly knew all along that he wasn't able to defend Chad at trial if he was going to be potentially sentenced to the DP. But we are 2 months out now, and he has now put forward this motion saying that he would like to recuse himself from the case. We're 2 months out. Now, he's also said that part of the reason why is because there's no money left, right? So he said, okay, well, I would have to do this all on my own. A, I'm not certified to do so, but B, I'm not going to get paid. Now, wait till you hear what he actually puts forth in his oral argument, and you'll see that it's slightly different to what I just said was in the written argument put forth to the court. And it's very interesting because of the fact that it deviates a fair bit from that written argument, and that will be called out. So you can imagine he has been waiting for this trial for a long time. And when I say waiting, he hasn't been hoping to go to trial. He's quite happy to be sitting around waiting for the trial. And also his case was severed from his co-defendant, and he had the advantage, I suppose, of his counsel being able to watch the other trial take place. So if you remember, Lori Vallow Daybell had her trial last year. John Pryor got to watch the other trial take place, see the questions that were asked of his co-defendant, see exactly how that all panned out, and use that as strategy for his trial. So there was actually a continuance of a year for Chad. And you can imagine that everybody involved now, except Chad, would really, really like to get this to trial in 2 months. So without further ado, let's get going. Oh, we'll just see what Online Red says first. When that came to light, her lawyers stood fast on them, but so fast on not giving up speedy trial. So that was the remedy. Chad and Pryor chose to waive speedy trial. To waive speedy trial. That's how the case got severed from a double trial. Yes, exactly. Okay, what's this? Don't they make the lawyers promise not to pull out even if the money runs out?
Yes and no. Depends how close to trial it is. Like if you have trial tomorrow and you're like, my client hasn't paid me, the judge is being like, tough, you're still doing it. But if you're like months out, then maybe, but the judge has to sign off on it.
We'll find out in a minute. Tilly, I know you mean death penalty, but I hear DP, and well, just don't look up other meanings. Yeah, well, it depends if you've been on Tinder lately. It depends. Okay, let's get into it, guys. And this is a pretty spicy one. It's a pretty spicy one. I thought it was going to be pretty dull, but no. I started listening to it, and I was like, I have to stream this. I must stream this. And by the way, it says it's 2 hours, but it's not. It's about 50 minutes because they go into closed chambers.
We are live streaming this proceeding.
Obviously,
we'll be on
we're
the
not going
record
to
on
be
case CR
watching
22-21-1623.
I'll just turn it up.
State of Idaho versus Chad Daybell. Scheduled this morning is hearing on defense counsel's motion to withdraw. A couple of preliminary matters before we get started here. The court will note there is an order governing courtroom conduct. The court is live streaming this on the official YouTube channel of the Idaho Supreme Court. I'm not permitting any other recording, video, or audio of the proceedings. So if you have a device that does that, that's not permitted. In addition, if you do have devices that make noise, please make sure they're silent or turned off to not disrupt the proceedings. And that's all set forth in the order governing courtroom conduct that's in effect for this hearing. I'll note on the record that the state is represented this morning by Rob Wood and Lindsay Blake, prosecutors for Madison and Fremont County. John Pryor is here with the defendant, Mr. Daybell. and the court scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion, also filed January 11th. Court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then, yesterday on the 17th of January, filed a objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order. And I provided copies of that to counsel, but it does have some relevance to today's proceedings. So let me confirm that. Mr. Pryor, you would have already had a copy of that order, but from the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your Honor, they were provided to counsel today.
Okay, thank you. And they're doing construction right through the doorway here, so counsel could speak up probably into the microphones, unfortunately. Try to make the record
hold them in contempt.
Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today? Ms. Blake. All right, Ms. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit arguments in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge,
They're really pissing me off.
The microphones are doing quite well, and that I should probably, and is my voice at this point acceptable, Madam Clerk, in terms of the tone? It's
No,
not
you sound like a
washing out?
female.
Yeah, it's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors and got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, you know, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court.
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval.
Josie.
At this point,
Thank you so much.
Where this court, I don't think, is obligated to, appoint an attorney. Mr. Daybell has private counsel.
So appreciate it.
I want to state to the court that I don't desire to get off this case.
Okay.
I want to
I'm
stay
going
on
to
this
pause
case.
it for a second because I'm going to say thank you to Josie. That's amazing. Thank you, Josie. And the people who received gifted memberships are Hurricane Holly, Rocky Renee, S, Justil Kun, okay, I feel like David right now. Diwiaz, Melissa Simok. I know Melissa. Is that it? 1, 2, 3.
Hurricane
4,
Holly, Rocky, Renee S, Justil Kuhn, Dweez, and Melissa Simok.
Okay, cool. That's awesome. I can't pronounce all those names, and I feel like David not being able to pronounce names right now, but that's amazing. And welcome all new members. And Josie, you just rock. I love you, lady. You are one of my first friends on YouTube and one of my best friends on YouTube. I just adore you. And Josie is one of the creators of the Wrongful podcast.
Yes.
And that is just an incredible thing that she does for the Zachariah Anderson community. She's a great supporter and helper of that community. And I encourage everyone to go and listen to that. And by the way, in just a few hours, since we're talking about the Zach cause, David tonight is going to be running some incredible footage that has just come to hand, and that is the Zach's interrogation and also Sadie's interrogation. So I believe that link is up. Is it?
Yeah,
I believe it is. Yes. Yes, Wrongful podcast link. I'm just going to put that one on the screen. And guys, if you could find the link for tonight's broadcast by David, we all need to get over there. We all need to be watching that one and supporting that one. It is going to be huge, as Mr. Trump says, huge viewing experience. I can't wait to see what was said behind closed doors. First time ever, guys. David's working super hard to get it already edited and for our viewing.
Yep.
So yeah, make sure you're there
and
for that.
I'm excited now that I know you can request evidence directly from the Kenosha police in this trial and other trials.
Other trials.
I filled out the form. I'm waiting to hear back. So
huge.
Yes.
This is huge news. Wow. Dave
so
doesn't
I didn't
have
even
to read stuff, right? No.
So I had no idea you could just go to actual police stations and get this stuff, even stuff that's not introduced in court. So I'm really excited.
Yes, but we don't talk to cops. No.
Good point.
Anyway, that's amazing. Yeah, guys, so if we could find the link to that, that'd be great. Appreciate it. Thank you so much, Josie. Okay.
Sure.
And I also want to pause it to speak because we're just about to get to the really juicy stuff that Mr. Pryor is about to say some things to the judge that are completely different to his written motion. So let's go.
And regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So
Right, and that's correct, Judge.
this is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand. But when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, and if I was unclear in my my declaration, Judge, that's
I'm going to hold my breath until I get paid.
The only way for Mr. Daybell to get appointed 2 capital qualified attorneys, and the only, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify.
CLEs are really boring.
I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token,
it's not fair.
Primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get 2 capital qualified attorneys to help him with this case is if
I want your cigarettes or your cigarettes or your cigarettes. I want my cigarettes.
Prior, going back to your preparation for trial, of course, this is a capital case.
Do you know
And
that
if there's
reference?
A conviction in the case, then under Idaho Code 192515, there's a special sentencing
One
proceeding.
flew over the cuckoo's nest.
And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the
Of course he wants
defense
to get paid, Liz.
as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but
It's just,
I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue because that is a trial issue and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32. And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point to go through those issues, and then we'll come back on in public proceedings. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security while Mr. Daybell is here. We will close this portion of the proceedings, and also for the bailiffs, if you could just make sure no one's within earshot of the a doorway as well, to make sure it's not carrying through on the microphones. And I appreciate your accommodating that. We'll also, of course, stop the proceedings from being live streamed, and then we will come back on the record once we're ready. We'll take a brief recess while that occurs.
All rise.
Okay. So this is the beauty of being able to watch this afterwards. We get to flick forward. Basically, that was a bit of a shit show. He didn't make much sense, guys, did he? Is anyone else confused?
I think basically he needs another co-counsel, especially one that's DP certified. But for whatever rules there are, if they hire a second attorney, that means he won't get paid. He wants to get paid.
Well, he won't get paid anyway. They're out of money.
No, but he's indigent, I think. So I think he can still get paid right now. But if he hires a second attorney, then he won't.
Yeah, the only way out of it now is for, he's saying the only way out of it now is for him to step down.
And find a DP certified.
Yeah, yeah, exactly.
Yes, apparently.
Yeah,
So I get where he's going. It's a very, and that's why I wish David was here, because he could probably, I'd be interested in his opinion. But I think basically
he's to be here, but yeah, he's yeah. I had to talk to him prior. And prior.
So I get what he's saying, even though he's not saying it very well.
He's saying it extremely poorly, which is frustrating. Yeah. And I'll give you a little spoiler. The state's going to absolutely throw it at him in a minute.
Oh, really?
Oh, yeah. And it's going to be a shit show. But
so the state's objecting to him leaving or to hiring a second attorney?
No, they're objecting to him leaving. Basically, it's going to be basically, this is too bad for you. You should have said this much earlier. What have you been doing with your time? You knew this was coming. And if you were going to try and step down, you should have stepped down a long time ago. You knew that the death penalty was on the table. You knew you weren't certified. So what's this? Really? We're 2 months out.
So the state's like trying to, yeah, this comes down to ineffective assistance of counsel.
Yeah, exactly.
And the state is now trying to get a conviction with this on the record. That's absurd.
They're not happy. They don't know. They don't want it to be ineffective counsel. They're very annoyed that we're now at this point and he's left it this long to try.
No, I understand that. Yeah. But they're annoyed. But if they go forward, then you have a potential for ineffective assistance of counsel appeal if he's convicted. So the state should delay, even though they're annoyed.
Oh, they really, really don't want to delay. And that I'm not going to give any more spoilers.
Okay, yeah. But I haven't seen it, so.
Yeah, okay. So we're getting back into court now. Before we go back onto the stream, I'd like to say welcome to a couple of new people here. So who do we have? I like to dissect women. Hi, nice to see you there.
Jesus H. Christ, Brandon. Oh, that's very Hannibal Lecter of you. Nice to meet you.
It may not be Brandon. It may be one of my new friends from over the
Could be.
potentially criminals Discord. You never know. There are some people with interesting names over there.
Charming.
Hi, Crime Spies. I haven't said hello to you yet. How's it going? Who else we
You
got?
have some interesting friends.
I do. I'm making all sorts of friends all over the tubes right now, and I haven't said hello verbally to Brokeback Baker. How are you? And Brokeback Baker says he really isn't making a convincing argument if he wants out and thinks it's best for his client. No. Well, on one hand, he's saying, I really don't want out. And then he's saying, I do want out. And then he's saying, I don't want to get paid. And he's saying, I do want to get paid. He is all over the place for a lawyer, a seasoned lawyer who's good at making arguments generally. This ain't a very good argument.
I think he's trying to argue both sides and try to get paid. And he's saying if he has to do it without being paid, he will, but he really doesn't want to. But I don't know.
Yeah, it's a movie quote. It's cool. It's cool. We're very open-minded here.
Mad.
EU. Aren't you glad you live 5,000 miles from those new friends? Hey, you wouldn't believe the kind of things we see here. I have to survive potential death every day. Every day. I'm pretty tough around here. Okay, let's keep going. All right, so basically they went into chambers to discuss something that could have been potential trial strategy.
Wonderful.
All right, we're back on the record on KCR 22-21-16-23, State of Idaho versus Chad Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition,
how are you, love?
Conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their arguments for the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present arguments for the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. And from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has, in fact, done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions, one being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they
like my
counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor.
Oh,
What's frustrating for the state is back in January a year ago,
okay.
both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial.
Yeah.
The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, the state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating. But in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point.
Yeah.
The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality
Everybody
is that working
poops.
24/7, Mr. Pryor cannot be prepared for trial. What he's indicating is he would be ineffective at trial.
Oh,
What
wait,
he's
I have my
presented
cell
today
phone.
is
Never mind.
no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today, what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case, and I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here. But we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested.
Or prosecutor.
Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't
I
getting
would
paid.
think so. But
Today,
okay.
at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, Does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think we've
Like, I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case, and as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it. Because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for the argument and response, Ms.
Judge,
Blake.
Let's just be clear here. So the reason I think this is poor form is because he hasn't been prepared with this motion. He's come in with a completely different argument to the one that he's put forth in his written affidavit. So he came to court and he said, "Oh, but I don't need to be paid, and I don't want off the proceedings. I don't want to recuse myself." But he's put forth a motion to recuse himself, and he said that the reason he can't, he needs to step down is because he's not DP certified, and that he can't be prepared in time, and he's not going to get paid. But then he came right up in front of the judge and said, "Oh, but you know what? In all honesty, I don't need to be paid, and I don't want to step down." And it's like, well, which is it, dude? Make your mind up. Like, he's been really, he's not put forth a coherent argument to the court, and all these other things that are being brought forward are fair now. Like, he's fair game because he hasn't stuck to his point. So I think it's not good form on his behalf. Prior, he's a good attorney. He's better than this. He should just stick to his guns. He should have written a motion that he comes forward and sticks to exactly what he meant to say right from the beginning. And he even said, "Oh, if I wasn't clear, then let me clarify now." But then he went and went back and forth even when he was speaking in his oral argument there at the beginning. So I think that's poor form. And he leaves himself quite open now to have these arguments put forth to him. So yeah, that's what I'm talking about. Only public defenders really get DP certified because they have to. I suppose, I don't know. But he's had a fair bit of time to consider this. And my opinion is that he really thought he was going to get that DP taken away. He was pretty confident in himself that by now he would have had it taken away, and it hasn't happened. And now he's kind of stuck between a rock and a hard place. Yeah. And he's like, oh, crap. Now what are we going to do? I'm stuck. And yeah, it's outside his field of expertise. And he didn't think that he would be going to trial. He didn't think he'd be 2 months out going to trial and he would have a DP to think about. You'd think you'd have a DP to think about. I need to hear EU say whittle wikis, wikes, wicker, widgets, willies. There you go. I hate to tell you this, but you've been muted this whole time.
Tell her. God damn it.
Shut up. Shut up, Bobby. And what did you change that to? What is that? What's your photo now? I like your old photo. Stop changing the photo. Your photo is great. DP or not DP? Something, I guess. Same thing, I guess. Okay, let's keep going.
To DP
Well,
or
this
not to DP?
2 points we will
Those
have
are the
to agree to
questions we
disagree
must
on.
ask.
Well, sometimes we disagree. Sometimes. Hey, has anyone? It's a prawn, is it? Don't come the raw prawn with me. That's the thing we say here. I don't know if you guys say that, but we say
No.
that. Anyway, let's keep going.
Respond.
I was going to allow your response, Mr. Pryor, so go ahead.
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today.
What?
This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is this, is that I disagree with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult, and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money. And I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on in this case, and I have to do this by myself, and the court recognized the
You've been
workload.
on a case for 2.5 years by yourself, and
I have.
all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start.
100%.
None of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial, essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, you figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, and I would like to have continued that. But he sees the effort that needs to be go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law, and the way the law is written, and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognize, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's going to, get the trial that he deserves, either I find someone to help me, which I did starting in with this court in January, but well before that, and to no avail, or I have to make the difficult choice. I understand it's 2 months before this trial. I understand that, and it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree the arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial, and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So that will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly.
All right.
Okay, so just to clarify, they never said that he was being effective before, just that he could be ineffective in the future if he was working on his own 24/7, trying to do the whole trial and having the death penalty, DP, on the table. Now, what's the bet that back in chambers, there's still, he is trying again to get the DP taken off the table, trying for a last minute plea deal. What do you think, Dali?
That could be too. He's it goes forward, just take the DP off, trying to trick him.
Come on, let's go. Come on, we're 2 months out. We're 2 months out. Let's do it. Come on, this is too difficult. We're never going to get anybody at this late stage. If you really, really want to go to trial in 2 months' time, this is all too hard. There's no other attorney that we're going to get up to speed in time. It's all going to be too expensive, too difficult. Chad wants me. I want Chad. Chad and I sitting in a tree. Come on, let's go. Just take the DP off the table. Let's go. Come on, let's go. I reckon that's what's happening in chambers right at this point, right now. And if that's what this is all about, it's clever.
Yeah.
It's clever.
Very clever. Yeah.
It is. It's a strategic move by Pryor.
It's a bold strategy, Cotton.
It's bold. It is bold. But I don't think it'll work because they've held out this long. They've held out this long. And people really will be mad if the state folds. If the state fold.
Yeah, that is very true. Yeah.
Could you bring it up, please? I'm
trying.
Cool.
Yeah, because you have to get a DP qualified jury. A death qualified jury is much more likely to convict. Mark Richards, once said that if they wanted to convict OJ, they should have gone with a death penalty. because
State
you have
wants
to,
leave on the table. If nothing else, it helps the state with getting more jurors favorable to them. Right.
because every juror has to be capable of voting for the DP.
Is he in jail? Hell yeah.
Yeah.
Hell
Oh, yeah.
yeah.
He's a naughty minx.
Oh yeah.
I don't even, somebody on with the DP, they don't get bail.
You know what this guy did?
No, but
You don't?
no, not really. I didn't pay attention to
Okay.
his wife.
Okay. Well, I mean, they're in it together. So
Are they?
she's already convicted.
Yeah,
So
I know
what
that.
we're talking about here is assuming that he's found guilty, which sorry, but he's going to be. And I make no apology for that. I'm not the only person, and you can talk to Danny, for example. Danny was on this yesterday, and she's very happy to just announce flat out that she wants this guy behind bars. But he and Lori Vallow Daybell, they at his property, on their property, was found the very mutilated corpses of Tylee, the 16-year-old daughter of Lori, and JJ, who was, I think, 8 at the time. And when I say mutilated, I mean like sacrificial mutilated.
Jesus.
Yeah. And that's just those two. There are others who have just disappeared out of the lives of Lori and Chad, especially the wife of Chad, who just was unalived only weeks before Lori and Chad had their magical wedding.
Aw.
On the
Happy nuptials.
Yes, on the beach of Hawaii.
Romantic.
With ukuleles and all. Yes.
Aw. I love ukuleles.
And apparently, as far as Lori was concerned, it was all because they were saving them from demons.
Oh, naturally.
Yes. So this guy is very much in line for the DP. Very much.
I see. How many charges of unaliving?
3, I believe, or maybe 4. 3.
Oh, okay. I thought it was
3.
just 1.
No, 3.
Oh, okay.
Well, she went down for 3.
Okay.
There could potentially be a 4th as Charles Vallow, who was and if anyone in chat who knows about this, got to stop those demons. Yeah, just casual Mormoning, everybody.
Yeah.
Yeah.
Gotta stop them semen demons.
Yeah. Charles Vallow was her ex-husband, and he was apparently also possessed. So they had to fix that.
Of course.
Yeah. So there are lots of people disappeared out of Lori Vallow Daybell's life. And they especially started disappearing once Chad appeared in her life. So it's 3 in Idaho. It's 3 in Idaho. There's 1 in Arizona. Right.
Yeah.
And that's what the Arizona trial is about.
I'll go to that probably.
He's not charged in Arizona.
We never get public trials, I only know if like Jodi Arias and Michael Turney are the only 2 in Arizona. So I'll go to that one when it happens.
Yes. Lori had her brother unalived her hubby, but Alex, the brother, is unalived as well. We're not sure. I can't remember the details of how Alex went down, but Alex was a co-conspirator, and he had something to do with the kids. It's all horrible. This whole thing is horrible and twisted. And the evidence that came out at trial for Lori was just shocking. In AU, is there the short drop and sudden stop? No, we do not have that here. And thank you for the super chat.
Do you have any DP
Brandon? No. Not since like the convict days, a long time ago.
Okay.
I think it was around the early 1900s. It's been a long time.
Oh, aren't you sophisticated?
Yes, we are. I'll have to look up the exact date, but it's been a long time.
Oh, welcome back, Liz.
Hey. And thank goodness we don't. I am very much against the EDP myself, and willing to argue that with anybody, actually. So yeah, very, very much think it's completely wrong. Alex is listed as natural causes, heart attack. Yeah. Yes. Yeah, too many people in that family have just suddenly disappeared at a young age. Last capital Australia was 1967. Really, was it that recent?
Really?
I thought it was much earlier than that. But thank you for that, Tragic. What state was that? If you don't mind, do you have the information on that one?
Australia.
A state in Australia.
Australia.
Shut up. Potential criminal starting. Cool.
Oh,
I will
yes.
look at him once we're done. And we're not too far off. Cool. Let's keep going.
Yeah, ex-comer. Oh, and just pause real quick.
Oh, sure.
Yeah, the United States is really weird for all how high and mighty we are. We're also like the 5th most extreme for pro-choice rights in the world, like right behind North Korea and China for stuff like that. So as high and mighty as we get, we really aren't as good as some countries.
Yeah. Was this last person was in Melbourne? Pixie, Melbourne.
Oh, wow.
Melbourne, late 60s, for killing a guard while escaping from Pentridge prison. There you go. There you go. Australia doesn't exist anyway. Yeah, no, it doesn't exist anyway. You're right. It's not real. Y'all. I'm going to start saying y'all just for fun. No one says y'all here. It's just not a thing. All right, let's keep going. Ronald Ryan. Actually, that name rings a bell. Rings a bell. Okay. Let's see what the outcome of this was, guys.
All right, we've confirmed the live stream's begun again. We are back on the record on KCR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor, and I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. And I'll just quote that section. No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause. So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case. Has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the
You don't
counsel
say.
of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims,
F the state.
to seek a conviction if they believe they have the
no
evidence
rights.
to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial.
Oh, for fuck's sakes.
So the court has a duty to try to timely administer cases, and while the rules
Merrick
generally slow
Garland?
things down a lot, there are reasons for that, but at some point, the court has to
Oh,
consider.
prosecutors have a right to a
timing
speedy
here.
trial.
That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief
That's the thing.
continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available
That
attorneys.
sounds like a you
Quite
problem.
frankly, I don't have any idea who would be appointed of the 2. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that. Mr. Pryor, we had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one is coming into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the 2 concerns here raised in the motion really are, number 1, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not,
Kind of like
in my mind, rise to
prostitutes.
the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client. Although it may be difficult and he apparently will not be able to be compensated, it's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today. And I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference.
Too bad.
So, Mr. Pryor, do you have any questions on my ruling?
No, Judge, thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
Well, he shouldn't have said that thing about I am happy to do this for free.
Yeah.
That was dumb. He should never have said that. He should never have said that I don't want off the case and that I can do it without being paid. Those two things should never have come out of his mouth. That was stupid. Anyway, Stray, thank you. That is so sweet of you. You are just awesome. You're just the loveliest person, and you give so much to this channel, so much of your time, and then you go and give a gifted membership, and you've already done that already this month. You I think twice already, actually. Thank you so much, and that's really nice of you. He did. No, he didn't. He said that his motion is denied. He's staying on. He's staying on, Matt. Yeah, motion denied. We all love you, Stray, and Dizzy will be so happy. I'll let Dizzy know that she got a gifted membership. That's fantastic. Oh, you're trying to get Tilly pro boned. Oh no. Pro boned. I'm sure that if Tilly sticks around, she'll get one. You are welcome to take on the beast of burden calling keeping LawTube afloat. Sorry, I don't think he would have gotten off the case. Oh, is that what you meant to say? Hey, fair enough. All right, so I've popped a few links in chat. They're already there, so I don't need to keep you guys any longer. Make sure that you are on Dali stream tomorrow. Jensen is at 2 p.m. Then we have Becky Mails. It'll be a special reaction stream to the conference for the pre-conference, whatever it was, evidentiary hearing. And then we have Here Safer Days, 3 p.m. on Sunday. Make sure you're there for all those things. The links are all in chat. Now we're going to redirect over to Sean. Make sure you say EU Dali raid, whatever it is that we're raiding. Raid.
Yeah.
And we
do not say. Never mind.
Don't say the thing. Don't say that.
Don't say that.
Just say raid.
Just EU and Dali raid. See
that thing. Yeah.
I'm being a good boy.
There's a lady on Lawyer, who dropped 50 memberships at a time. Yeah, she's in love with Peter. That's why. It's those ladies who are in love with Peter, and they also do it over on Rob as well. Just like, so in love. Yeah. Cool. All right. Thank you guys for joining us. That was really interesting. A bit of a break from gypsy content and all that kind of stuff. So have a great rest of the day. Oh, and I'll see you guys also
Wait,
later
X-Comer, what the hell did you do now?
What?
What
Yeah.
the hell?
What is that? What is that? Is that sausages or something?
No, that's like me holding a phone, I think, with... God damn it.
Okay, I'll have to look at that later.
Okay,
That
I
is
don't know what
awesome.
I
That
don't
is
know what
awesome.
that is, but
All right.
thank you, I think.
I'll see you over in Sean's stream, and also for Zach's stream later. Make sure that you're there for David's stream showing Zach's interrogation and Sadie's interrogation. I think it's at 7 p.m. or I don't know. Guys, just make sure you're there.
7:30.
7:30 p.m. Be there. Be there. Be
Yep.
there. Be there. So important. So important that we have as many people there as possible supporting it. Okie dokie. Bye.
Bye.